Hello, everyone, and welcome to the next installment of Galen Data Medical Device Innovation Webinar Series. I'll be your host today. My name is Abbas Salawala, and I'm the Chief Technology Officer at Galen Data. Today, we'll be hearing from Martin Gomez from Goodwin for a conversation on IP and patent strategies for MedTech companies that are building devices, software, or combination of device and software. We will learn how important IP is for MedTech companies, how to protect it, and general process and timelines for the protection. But first, some housekeeping items and a little information on Galen Data. Galen Data provides an FDA-compliant cloud for medical device manufacturers. The Galen Cloud provides a configurable platform for device-to-cloud connectivity that is compliant to FDA, HIPAA, and CE mark standards. We are ISO 13485 certified, and the product on AWS is Hydra certified as well. Founded by seasoned medical device professionals, our goal is to make medical device cloud connectivity available to all at a fraction of cost while saving months of development timeline. Galen Data allows medical device companies to stay medical device companies and not become IT companies. Finally, some quick logistics. As we're going through this, if you have any questions, you can type those in the Q&A section available through the sidebar. It's either on your left or right, depending on your client. We'll either ask those questions to our guests at the end, or if appropriate, I'll bring up those during our conversation. There's also handouts on that control panel with more information on Galen Data, its products, and a white paper on cloud connectivity. Also a reminder that a copy of this webinar will be sent to you via email. That being said, I'd like to introduce our guest, Martin Gomez from Goodwin. Welcome, Marty. Let's start with a brief introduction of yourself. I have a slide here about your bio. But tell me more about yourself. How did you go from being an engineer to being a lawyer, and how did you end up at Goodwin?
Yeah, thanks, Abbas, and thanks to everyone for joining today. I'm looking forward to the discussion, which, as Abbas previewed, will be about IP strategies for MedTech companies across multiple technical disciplines. But just by way of sort of brief background, as Abbas mentioned, I, like maybe many of you in the audience, initially got a degree in mechanical engineering with a focus in biomedical engineering. So at one point, I think I was on the path to, maybe design and develop products for MedTech companies directly. Through a couple of different kind of twists and turns, ended up deciding to go to law school and studied pretty heavily patent law, which is sort of at the intersection of technology and law, and joined a law firm, Goodwin, right out of school, and have been here for about 12 years now. I'm a partner in our MedTech practice. I'm actually the leader of our MedTech practice. My personal practice, and what we will sort of talk about primarily today, is IP protection strategies. But just for the sake of giving you an overview of the group, the model of the group is really to represent MedTech companies from the earliest days, literally sort of at formation, kind of through their life as private and really into public companies to the extent that MedTech companies become public companies. But really, most of our clients we start with when they're very early. We help them sort of implement a lot of the strategies that I'm going to talk about today, and we help them with a bunch of other things as well, including regulatory assistance, fundraising assistance, sort of corporate kind of legal guidance assistance. Usually culminating in a sale of the company or something of that nature. So that's the team, that's the group. It's kind of a custom-built group, really made for the needs of MedTech companies. We saw kind of a gap in the market for law firms that were really sort of focused on this sector. And so, as many of you are probably aware, intellectual property is a kind of a key critical asset for MedTech companies. And so, my personal piece of that is helping to protect the IP assets, and that's what I'll talk about today. You can go to the next slide. Great. So just a little overview for what I want to talk about today. Just first a high-level discussion, and I understand that the audience is probably somewhat wide-ranging in terms of kind of experience, where your company is at or what your company is doing, or even if you've formed a company yet. So some of this you may have heard before, but hopefully it'll be a good overview if you have, or a good review. So I just want to talk about sort of why in general companies should care about IP, what, why we spend so much energy, discussing it, and what sort of what all the buzz is about. Then, regardless of what that IP is, right, there's some basic things at the beginning of a company that I want to talk about strategically, ensuring that the IP that you create is actually owned by your company, regardless of what it is, making sure that it's inside the company and not sort of subject to other rights. Then I'm going to talk a little bit about sort of strategic selection of IP assets. That is going to be the meat and the bulk of today's presentation, because that strategy has changed a bit recently in light of sort of the convergence of the different technology spaces that we're seeing in MedTech. Obviously part of what Galen is doing is helping companies that are doing data connectivity and cloud infrastructure, in MedTech space, companies that are collecting data and using software and analytics and things like that, that's still relatively new to MedTech. And so sort of the IP kind of protection landscape has changed a bit. And so we'll talk about that. Then I'll talk a little bit about sort of, how you should think about working with IP counsel, when the right time to work with IP counsel is, how you select IP counsel, all of that good stuff. And then just a little bit at the end, because I can't help myself, on the topic of freedom to operate, because I think it's critical for every company to know about. Perfect. Okay, so why do we care about IP, right? So if you it's a maybe a bit of a tired metaphor at this point, but it comes up all the time, right? And if you ever kind of raise money from investors, or you speak to acquirers, you're talking to people about sort of the strength of your business, you often hear this term like, well, what is your moat, right? Like, what is sort of protecting competitors from taking market share from you or competing with your business? And so maybe a tired metaphor, but one that is sort of apt and is used pretty consistently sort of in the space. So if you think of your business as sort of your castle, right, and the way that castle is competing, the things that are inside the business is your product, your sales channels, your the customer relationships that you have, your employees, all of that, right, sits inside of the business. And what your IP is really, and there's different IP is used, the term IP is used sort of in different contexts in different ways, but in this presentation, and the way I think about it, is it's really all of the things that you're sort of kind of using to prevent competitors from encroaching on that castle, or sort of stealing the things that are making your business successful. And so a lot of people will automatically sort of conflate IP with patents, right? That's very common actually in the med tech space, and really in the medical device space, because for a long time, and we'll talk a little bit about why this was, or why this is, patents is really kind of like the only critical kind of IP that a lot of med tech companies had, or medical device companies had. But IP is actually a lot more than that. It's really any of these things, right? So any of these things that have sort of labeled as these gators here, right, are, it could be patents, it could be trade secrets. Frankly, your regulatory status, right, is a barrier to entry. If you have regulatory status and somebody else doesn't, that can be, part of your moat. The data that you collect, arguably that's part of your trade secret, but it's kind of an important enough subset that I have it separately labeled here. And then even things like first mover advantage, right? The first company to market to doing something. Oftentimes that's actually coupled with something I don't have labeled here, but it's your branding strategy, right? So you're the first mover, you have a brand, people sort of associate your product with a particular experience or a particular, quality of goods. All of that is competitive moats, to your competitors, and which ones you want to select, as we'll get into, is really going to depend on kind of what your competitive advantage is and what type of business you're building, along with a couple other factors. So it's your competitive moat, right? It can be a real differentiator, particularly in the med tech space. I mean, there are other industries where, not that they don't have moats, but that maybe, companies are analyzed differently, but certainly in the med tech space, it's a differentiator for investment dollars, and certainly for M&A dollars. It's something that, any investor and any acquirer is going to want to know that you have, and that you're going to want to be able to articulate clearly, and in a way that makes sense. it's an asset of your company. So once you have IP, particularly, in the patent space, but even in the sort of know-how trade secret space, it's something that you can license, right? You can give other people the right to use your IP in exchange for royalty payments, or you can cross-license. So with, these are all business decisions, but you can give somebody else a right to use your IP in exchange for your right to use their IP, and, joint ventures and collaborations and things like that. And then finally, and my practice, as I mentioned at the beginning, is really sort of like helping build IP estates, and helping those be sort of a catalyst and a tool to the growth of companies. I was earlier in my career a litigator, which I think is actually important for knowing kind of how when the rubber meets the road on these assets. But my goal is actually to try and keep my clients out of litigation, particularly early stage companies where, it can be a distraction and a drain on resources. But, if you need to, part of, having these assets is, if necessary, if somebody is sort of trying to attack your castle, actually bringing some sort of an offensive lawsuit. So that's a benefit, or at least the threat of being able to bring that lawsuit. And then, also as ammunition, defensive ammunition. So, sometimes, other parties that own IP assets will bring lawsuits against you, and, you can be in a much stronger position, a counterattack position, if you have your own IP assets that you can counterattack with. So all of that hopefully sort of, defends or gives some value to what I've been sort of building my career around. But that's why I care about IP, and hopefully, why the folks in the audience would care about IP as well. Next slide. Okay. So, now that we know, now that we've kind of got our minds wrapped around like why, we might care about IP. And again, I'm going to dig in a little bit more substantively around these assets, and when to pick which one in a few slides. But regardless of what your IP is, there's some sort of, I don't care if it's trade secrets, if it's data, if it's tech, ideas, whatever it is, there's certainly some things to consider around ownership, right? Because if you remember the last slide, right, we want all of that stuff to actually be in the castle or in the company, because that's what investors are investing in. They're not investing in individuals. I mean, colloquially, you hear sometimes that they're investing in the founders, not the company, but ultimately they're buying shares of the company, and so is an acquirer. So we want the IP to be in that company and not, somewhere else. So particularly at the front end, right, you really want to sort of, separate the ideas for whatever company you're starting here from any other employment or any other engagements that you may have had as a founder. Many people, start MedTech companies after being employed by another MedTech company, or after being sort of engaged or a participant in some sort of a PhD or academic program. And so, you really want to sort of understand with your other employment or your other, participation in a program, what are your obligations? Did you have, did you agree to assign ideas, to another entity such that, you actually don't own those ideas anymore and another entity owns them? You really want to sort of do a kind of a deep dive and an analysis on what you agreed to with sort of your current employer. And then to the extent that you're doing, kind of anything, on the side, right? If you're still working at an employer, or still engaged in a PhD or a professor program, and you're, doing the company, initially not full time, you want to make sure that you're keeping everything very separate and you're not doing anything. Oftentimes, your agreement with your existing employer will say, you can't do anything. We own everything that you do. It used to be, sort of while you were on premises and sort of on, using our resources. These days, as everyone probably knows, with remote work and sort of the flexibility of kind of the work day, it's a little bit more kind of gray. And some employment contracts have caught up with that, and others haven't. So just something to analyze before you kind of, start a new company. Make sure that, the IP that you're planning on putting into it, you actually own and have the right to assign in. Once that's cleared, everyone in the company, the founders, and then sort of, initially the founders, right, should assign all of their IP into the company. And normally they do that in exchange for their founder shares. So in exchange for their sort of like initial equity in the company, founders will, assign IP, right? Because you have to give something in exchange for equity. And so oftentimes with founders who sometimes they are, but not always bringing like cash to the table, a lot of times they're just bringing their ideas and their energy. And so you'll actually see that often founders assign IP rights into the company in exchange for their founder shares. After that, sort of all other employees, right, anyone else that joins the company or anyone that you engage with who's a contractor or anyone that's going to be sort of developing or creating IP, you should get a contract signed by them that says, any IP that I develop or generate, within the scope of my employment or as a contractor is going to be owned by the company. And there's certain kind of magic language that, people diligencing your company are going to want to see in these agreements. So it's good to, consult with a lawyer to make sure that you've got sort of the right kind of forms in place for that. I actually link at the bottom of this slide to my firm has a free resource actually that we make available that generates sort of a lot of these kind of basic documents that startups should have. So you might want to check that out. It's called the Founders Workbench. And then the last sort of agreement, that I think every sort of from an IP perspective that every founder or every medtech company should have in its arsenal is the NDA. The NDA, the non-disclosure agreement, doesn't I mean, you can put whatever you want in them, but I've already sort of mentioned sort of an IP assignment agreement. Sometimes an NDA doesn't have any IP assignment language in it, but it just says anything that we tell you, you need to keep confidential and you can't tell anybody else. And, as we'll see later, that's important regardless of whether or not you want your IP to be protected by a patent or by a trade secret. Next slide. Okay, so we know why we care about IP. Hopefully we know sort of regardless of what the IP is, we want it in the business. Now I'm going to start to get in a little bit here to like the different strategies that you might want to think about for protecting your IP. And I think to kind of set up that discussion, it's helpful to think about, kind of where MedTech is going. And I apologize, at least on my screen, this graphic is a little small and I made the graphic, so it's on me. But if anyone actually wants to see the original of this, that both of these graphics were taken from the KPMG, the Medical Devices 2030 report, where they kind of analyze where they see the industry going, in the next, less than a decade at this point. So the industry is certainly projected to grow, right? That's sort of what the graphic on the left shows. The graphic on the right is more interesting to me, which is kind of the roadmap of kind of where that growth is projected to be coming from. And so, I'm not going to go into like this graphic in its entirety, but basically sort of they set out, kind of the four quadrants of sort of technology areas that you could break sort of the medical device space into. And then the most sort of interesting part to me about this map, and I think I'm seeing it in my practice, I'm sure you all are probably seeing it in your interactions in the medtech space, is sort of this line at the top of this graphic, which says patient and consumer data sharing technologies will complement the 4 medical device categories below by 2030. And as you can see, as you kind of trace this graph out radially, it's really sort of the ability to do enhanced patient and consumer data sharing and analytics and all of that sort of stuff, which is implemented often, not with mechanical hardware devices that the medical device industry is very used to and has been for the last 30 or 40 years, 50, going back how long we've had this industry. But now a lot of the growth of the industry is being built upon different types of technologies. And anyways, I just wanted to highlight that here because that is going to drive some different IP strategies. Next slide. All right, so now we're going to get, kind of into the meat of it here. Remember, I don't want you to lose sight of these are oftentimes a choice between protecting something as a patent or keeping it as a trade secret is the decision point that is often faced by medtech founders or medtech companies. But these are not the only types of IP. I tried to highlight that in the initial slide. So, this will be sort of a subset, of the analysis, but I think any thoughtful company in this space should really, engage in sort of a full spectrum sort of IP analysis. And I'll talk a little bit about that in a slide or two around, how I like to kind of conceptualize or think about that. But one of the biggest sort of decision points tends to be, okay, we have some technology. do we want to protect it with a patent or do we want to keep it as a trade secret? And so to sort of really understand, which of those is the right selection, you need to understand a little bit about both of these assets. So a patent, I'm going to go a little bit off script on these sort of boxes for a second, just to give a little bit more background. So a patent, right, basically the deal with a patent is if you come up with something that meets the criteria for patentability, which we'll talk about, which is basically that it's eligible for patenting and it's new and kind of different than stuff that's been done previously. And if you submit an application to the government and convince them that you've come up with something that meets that criteria, then they will give you exclusive rights in that idea, meaning that nobody else can do what that idea is unless you give them permission to do so for a period of 20 years. And the philosophy there is that, that offering of exclusive rights motivates people to invent things. And so the government is, willing to grant those exclusive rights. But then at the end of those 20 years, those patents expire and everybody in society can benefit from what, was invented. And the way that they do that is in order to pursue a patent, you need to prepare a fairly lengthy document that describes your invention in a good amount of detail. And sort of the criteria for that is that you need to sort of explain to others how you would sort of make and use and benefit from the invention. So, one area where, you can see where an example of this is made very clear, and there's examples across many industries, but I think many people are familiar with, when you go to the drugstore and you see the generic version of, the Sudafed, right? And it's branded as the Wallfed or whatever, the generic, sort of, those are usually the exact same thing. It's just the initial drug came off patent and then everyone is free to make that drug. So that's kind of how patents work. Trade secrets, a lot of people ask me sometimes, what do I need to do to apply for a trade secret? It really is a trade secret. Trade secret is really just sort of your strategy there is, it's basically anything that you consider to be confidential. I mean, in legal circles, there's kind of a technical distinction between trade secret and confidential information, and we could get into that, but it's not really necessary for this discussion. Anything that you consider to be confidential, and that is, bringing some benefit to your business, you can consider to be a trade secret. And the strategy there is, you don't apply for anything, you don't do anything. The strategy is just, I'm going to keep this secret. I'm not going to tell anyone how I do this. I'm not going to tell anyone, the details of this, particular algorithm or particular manufacturing technique or, whatever it is. And if I don't tell anyone how to do it and nobody else figures out how to do it, then that's my strategy. That's the IP strategy. And so the key differentiator here with that sort of background is with a patent, if you decide to go down the patent route with your technology, even if somebody else independently comes up with your idea. So let's say, a group of folks in Boston, which is, I didn't mention this, but by the way, I'm based here in Boston. If somebody here in Boston, comes up with an idea, right, and they file for a patent on it, and they receive that patent, right? If somebody else, in California, let's say, has the exact same idea, right? They never had any access to the company in Boston's idea. They never saw their patent application. They can prove all of this. They've been in some clean room, completely isolated, but they come up with the exact same idea. It doesn't matter. Independent conception is not a defense to patent infringement. The government has rewarded you with your 20 years of exclusivity. Doesn't matter how somebody else comes up with their idea. You can stop them from practicing whatever is covered by your patent. That is not the case with a trade secret. So if you decide that you're going to keep something as a trade secret, and then somebody else independently comes up with that same idea, they come up with the same algorithm that you had, or the same data processing technique, or the same manufacturing technique, or whatever you decide to keep as a trade secret, somebody else comes up with the same idea, they're totally free to practice it. If you didn't file a patent on it, and your strategy is, I'm just going to keep this thing as a secret, and somebody else independently comes up with it, they're free to do it. And that really is, kind of the primary. We'll kind of talk a little bit about how that plays out in the following slides, but that is kind of the key difference between patent and trade secret. Next slide.
One question that came up on the subject, maybe it's the right place to address it, but the question was, we have shied away from patents because of concern regarding reverse engineering once our technology is disclosed. We have relied on a trade secret approach, but at what point does that option really not viable?
Yeah. So, if your device is reverse engineerable, right? So, and this is actually why, like for a long time, the medical device industry only relied on patents, because the way I think about reverse engineering is, once I put it into the market, somebody else can take it apart or whatever you want the analogy to be and figure out how it works, right? If your product is reverse engineerable, which most mechanical, hardware elements are, then trade secret is not a very good option for that type of a technology, because by the virtue of you selling it into the market, somebody can figure, you basically lost your secret. Like, it's not viable protection. So that's why oftentimes you see with reverse engineerable technologies, they are protected by patents, because that's the only way to actually keep them protected. The more challenging sort of discussion is when you have a technology that is not reverse engineerable, like many software technologies, right? That you may push out some object code that's being executed, by end client devices, but the algorithms themselves and everything, is on some sort of, again, hopefully if you're working with Galen, some very secure, cloud server somewhere. People don't have access to the actual algorithms themselves, right? They are not reverse engineerable. And so there is where it's actually possible to keep it as a trade secret, but given some of the considerations we'll go through, it may not be the right decision all the time, and we'll walk through that over the next couple slides.
Thanks for that info.
All right, so what the kind of takeaway that I want to take from that overview is, you really need to be strategic about sort of what IP asset, what tool you're going to choose for what piece of your technology there is. And by the way, lots of companies have patents. They have some things they protect by patents and other things they protect with trade secrets. Depending on, if you're a combination device, right, or combination technology where you have a piece of hardware but you also have software infused in that hardware, you might have patents and trade secret, right? If you're just a software company, or there's all sorts of mixes and matches. But for each IP asset, you want to be very sort of thoughtful and strategic about the type of IP tool that you're protecting each of your assets with. And some of the things you want to consider are, what is the likelihood? Well, first of all, and I should have a bullet here for this. The first is my technology reverse engineerable? Because if it is, then patent is almost certainly the right way to go, because trade secret is not really viable there. But then let's say you have a technology that is not reverse engineerable. Well, what is the likelihood that somebody else is going to independently come up with this? If it is, right, then my trade secret's not going to be super valuable if somebody else comes up with this, in a very short period of time. Second is detectability of the invention, right? So let's say that you do get a patent, right? You file for a patent, you put in a public document exactly how your technology works, and you have a patent on it. Remember, we said one of the benefits of having a patent is being able to actually sort of enforce it and bring that offensive lawsuit if you have to. Well, are you ever going to be able to tell what somebody else is doing? I mean, you don't need to have 100% certainty to bring a lawsuit, but you usually want to have at least some suspicion that somebody is infringing your patent. So if your patent covers something very detailed, very deep in your code stack that you wouldn't really be able to tell by some company's public activity if they were infringing it or not, that's a consideration. And then another consideration, we'll talk about this a bit too, is speed of innovation, right? So we talked about the benefit that you get is a 20-year patent term, but we'll look at this in a couple of slides. The process to get a patent can be lengthy. It can take 3, 4, sometimes 5 years to actually get a patent. So if the technology space that you're working in moves so quickly such that if you have to wait a couple of years to get your patent, that it's not going to be particularly valuable because the technology will have moved beyond that point, well, that's another consideration for whether or not patent is actually worth it or not. Next slide. All right. So this is a graphic. I put this in front of my clients sometimes, just to kind of conceptualize and think about all right, what are my IP assets and how should I think about protecting them, right? So I usually have people start with the circle of the Venn diagram in the top left here, which is, things your customers like/need about your product. That's a good thing to start with, right? What are the things that are delighting our customers? What are the things that they enjoy about, interfacing with our product? And that, but then there are probably things about your product, right, that people like, but that you can't own. Like, you know, that like you didn't come up with this feature. It's just a, it's a feature of your product that, people like. So in addition to things that people like about your product, you also want to sort of find the intersection of things that you can actually own, right? So what are new things, right? So what is the new stuff that we've come up with that people actually like, right? That's kind of the intersection that is the combination of the yellow and the red. You really kind of want to focus there. Those are the things you want to look to protect. And then within that sort of section, right, what are things that we can actually detect and potentially enforce, right? And I've oversimplified this graph, right? In addition to all of the other factors that I gave on the last slide, you can sort of delineate out, all right, well, these are the things in red that we want to patent, and then the things in yellow we want to keep as a trade secret. That's a really useful exercise to go through for any MedTech company. Next slide. Okay, and then this really just, this is a graphic that just kind of summarizes, again, or sort of highlights what I was saying before, which is, just sort of depicting it graphically, which is, we've got all these different types of protection. We've talked about trade secret and patent. I don't want to spend much time in this presentation talking about trademark, although I'm happy to, offline with folks. Just doesn't tend to be as important of an asset for MedTech companies. The other one is copyright, right? One thing to mention about copyright is that it protects the actual sort of like implementation of your software. So if somebody actually copyright protects all sort of creative expressions fixed in a tangible medium. That's a very kind of legalistic sentence, and people might be used to thinking about copyright as protecting like drawings or paintings or songs, right? But one thing to keep in mind is that the law also views sort of lines of software code as being this creative work fixed in a tangible medium. So your software code is protected by copyright actually the moment that you create it. There is a registration process for copyright, but it can be done after the fact, kind of right on the doorstep of when you want to enforce it, unlike patents in that way. So many times your software code itself is protected by copyright, and if somebody actually copies the actual lines of code from you line by line, that's actually copyright infringement. The problem is that it only protects sort of the actual implementation of the idea, not the underlying idea itself. So if somebody just rewrites your code a little bit, then they've no longer infringed your copyright, and that's where you may want to sort of have a patent to be able to go after them with. But anyways, the point of this graphic is really just to show there's all sorts of different protections. They kind of span the gamut from cost, right, that they cost, but also sort of the amount of protection that they afford. Next slide. All right, let's see here. So I'm going to talk for a second about sort of software technologies, right? Because if let's say that you have a non-reverse engineerable technology like software, you have an algorithm, a particular algorithm that is, and it's unique and different, and it's novel, and the way that you process data is different than has been done previously. And one of the things to consider if you're going to go with a patent is you're going to want to really maximize your chances of actually being successful with that patent. And there is an entire seminar that I could give, on, I actually in law school took an entire class on, and have spent, years of my career focusing on sort of getting patents in sort of this area of patent eligibility. Actually, boss, can I ask you to go to the next slide, please? Okay, so when you file for a patent application, I mentioned it earlier, there are certain hurdles that you have to get over. You have to sort of present certain criteria to the patent office to get a patent. I think most people, if anyone has sort of dealt with sort of like the device space before, one of those criteria is that the thing that you're patenting has to be new, and it has to be non-obvious over stuff that's been done previously. That's pretty well understood, and particularly in the medical device space. But there's this other criteria that historically has not faced many mechanical items, and still doesn't face mechanical items, which is that the subject matter that you're trying to patent has got to be eligible for patenting. There are certain carve-outs in the law that say it doesn't matter if you discovered this thing. You can't get a patent on, for example, natural laws. So, obviously if Isaac Newton, I don't think he was submitting patent applications, but Isaac Newton or whoever discovered the law of gravity, you can't own the law of gravity. It's a natural law. So again, could spend a ton of time on this, but one of the categories that you're not allowed to patent in, and this is in the patent statute, and there's been a whole lot of dispute over what this means, but there's a category called abstract ideas. You cannot patent something that is an abstract idea. Now, and again, I promise I won't drone on and on about this. This won't be a history lesson, but just to give a little bit of context to this, there was a period of time around sort of the dot-com bubble when people were getting patents on many, many different things, including business methods, techniques of doing business. And, banks were getting patents on like techniques for hedging risk in like the commodities markets, things like that. So the legislators basically didn't want people being able to get patents on techniques of doing business. So there was all these lawsuits, there was a lot of sort of fighting in the patent space, and as unfortunately often happens, we get sort of decisions from the Supreme Court that has kind of a lot of words in it, and they sometimes have unintended consequences. So basically the Supreme Court came out with this decision, I think it came out in like 2010 by the time it finally came out. And it had language in it that basically said, like, they were trying to get rid of people patenting business methods. What they really ended up doing away with was people being able to patent any method, right? And that was a problem because if you think about software, it's usually just methods of like performing things. So what all of that is kind of leading to, and again, we could do entire presentations on this. This is more of kind of an overview presentation, is there are laws out there and there are court decisions out there that can sometimes make it very difficult to patent software. One of the big cases is this case called Alice v. CLS Bank. And there's a framework out there for patenting software, but you have to know how to navigate that framework. And there's a lot of strategies, but it behooves you to work with somebody that understands the framework and that can present the patent application in a way such that your patent on software, if you want to patent software, actually has a chance of being allowed. Next slide. And then, on the slide that I had a boss kind of skip over, I was talking about sort of like some tests from this Alice test. This is a visual depiction of it. You can look at it later, but this is sort of, the process that the courts go through or that the patent examiners go through. And again, really the takeaway from this is if you're going to patent something that is non-reverse engineerable like software, make sure that you're able to sort of comply with this framework. Next slide. All right. Just a little bit about sort of the patent timeline for people that don't know. So what I really want to focus in on here is actually the lower slide here, or the lower timeline here, which is for those that don't know, oftentimes if you're going to file a patent application, you'll file what's called a provisional patent application. You have 1 year in which to turn that into a non-provisional or a full patent application. And then here's the kicker, and this is really what I mentioned earlier, which is you got to think about sort of how long, what the timeline of your technology is. You can oftentimes wait in line for a couple years, 2 years or more, to actually get your examination started on a patent application. And then, depending on how long your examination goes, you can wait, even a full another year until you actually get a patent granted. So I just sort of show this here because, again, as you're thinking about sort of the right asset for you, timing, is a consideration. There are some opportunities to compress that 2-year wait time, and I'll talk about that in a second. Next slide. Yeah. So I mentioned on the last slide, there is a process. I just want people to know, again, all of this is coming at it from the lens of, well, what's the right IP asset for me and how long does it take to get a patent application? There's something called a track 1 accelerated patent application. You can pay an extra fee for a small entity, which many, early companies are. It's $2,000, and probably to be explored more in depth at a later time. But as you can see, you cut your wait time way down, roughly in half, if you do one of these patent applications. So there is an opportunity to accelerate, but you have to pay a little bit more money. Next slide. Yeah, just so that folks kind of know, if you haven't been through the process before, right? If you do decide to go through the patent process, you basically, the way that it usually works is you file your patent application. The patent office will then sort of look at your patent application, and oftentimes they will reject it because they'll say this is the same as something that's come previously. And then you will sort of go through a process where you negotiate the scope of your claims. You might narrow your claims by making an amendment, as is shown here at the bottom of this slide. And you basically go back and forth with the examiner until you guys agree that the scope of things that you're looking for protection for meet the criteria for patentability. If you don't like what the examiner has to say, you can appeal their decision. But actually, to be honest with you, that tends to be a very lengthy process as well. So we usually try to get it through, in discussions with an examiner. Next slide. All right. So that's hopefully with those couple of slides, you've got a kind of a better understanding, of, all right, if I want to get a patent, this is kind of what I'm in for, and the considerations that I want to keep in mind. If, however, right, you have a non-reverse engineerable technology, like an algorithm or, software of some type, and you decide, all right, I want to keep this as a trade secret because all that stuff that we were just talking about on those last slides, the time, the cost, the having to tell people what I'm doing, I don't want to go through any of that. This is my strategy is I'm keeping it as a trade secret. If you do that, right, there's some other things that you just want to keep in mind to make sure that you're, going to be successful with that strategy. The first is keep the code secret, right? As I said earlier, it's not that complicated, but you've got to keep this stuff actually secret. So what does that look like? Well, you want to have good NDA, you want to have good confidentiality hygiene, make sure that anyone that gets access to that code is signing one of these documents, because if not, they're actually free to take that information. You want to avoid open source issues. This is not something that, MedTech companies have often had to think about in the past, right? Software companies have been thinking about it forever, but MedTech companies, this is kind of new, right? So the big basic takeaway is, listen, there's all sorts of open source software code out there, and some of it is very useful and very helpful to incorporate into your code decks. However, open source software is made available to you under a license, and there's good licenses and there's bad licenses. A good or an acceptable open source license is what's called a permissive license. A very common example of that is the MIT license. To be clear, you're not getting the code from MIT. It's just the license was written at MIT or is used by MIT, but it's commonly referred to as the MIT license. Those licenses basically say, okay, we're going to make this code available to you for free. You can use it, but you can modify it. You can make changes to it, and you can still keep that stuff secret, the modifications that you make. You may have some minor obligations like attribution or something, but you don't need to make the modifications public. The other type of license, which you want to stay away from, is called a copyleft license, copyleft being like the opposite of copyright that I was talking about earlier. And common examples of this are anything with a GPL, which stands for General Public License. On those types of licenses, if you use that code, yes, we're going to make this code available to you for free, but in exchange for that, you need to make available to the public under these same terms any modifications that you make to the code. So you can see, if your strategy is, okay, we're going to keep our code, our software code, secret, but we're going to put into that code open source software, and you don't have a good process in place, or you just don't even know whether or not you're using open source software code or not, and you get some copyleft software code in there, well, now all of a sudden your thing that is supposed to be very secret, and that's your strategy, it's a trade secret, technically you have to make all of your proprietary code publicly available as well. So again, big topic, but just something to be aware of. Make sure you've got good sort of cybersecurity and other, sort of protective, data protection defenses in place, right? Because once if you keep something as a trade secret, if somebody steals it from you, it's no longer a trade secret. You may have a cause of action against the person that stole it from you, but it's out there. It's this concept called you can't put the toothpaste back in the tube. Once you lose it, it's gone. And also consider employee mobility issues, right? Employees, we talked about obligations from prior employers, but keeping, employees that have access to your code, you need to be really careful and have contractual obligations in place to make sure that they aren't taking that code somewhere else. Because again, if you lose it, you don't get it back. Next slide. Okay, so that's, again, we've kind of gone through it relatively quickly. This is kind of an overview session, right, of like hopefully, identifying different pieces of technology, different, ways you might want to think about protecting it, the different considerations. This stuff is complicated, it just is. And so, I do like to just kind of point out, you know, it is useful to work with IP counsel on this stuff. People think about this kind of day in and day out, and so you probably do want to select some sort of an IP, you know, counsel to work with you. And your IP counsel, you know, they should really be a business partner in this regard, right? They should understand your business, they should understand your technology, and, you know, they really, you know, whereas they should be good tacticians when it comes to drafting patent applications and securing rights and all that kind of stuff, it's this kind of high level strategic stuff that you really want to look for, you know, in your partner. You want to have, you know, periodic meetings with them. Not only does that make sure that, you know, you're kind of staying on top of the stuff that you're sort of inventing, but also you get kind of periodic feedback on the right ways to kind of protect this stuff. Timing is important. One of the things that I didn't mention earlier, I did mention that when you're seeking patent protection, one of the criteria that the patent offices look at is whether or not what you've submitted on is new. Well, you can actually become prior art to yourself. So if you publish something and then, you know, a year later or 2 years later, you decide, hey, I want to get a patent on this, and you file a patent application on it, the patent office can actually say, nope, you can't get this patent because it's not new, because it's been done previously, and they actually point to your own prior publication. So it's a little counterintuitive in that way. There are reasons for the system, but again, working with good counsel can help you kind of avoid those problems. Next slide. Yeah, and you know, kind of more of the same here, right? You want to sort of make sure that IP protection is part of your development process. You want to sort of stay on top of it as you're developing at the design stage, while, you know, development stage, implementation. You know, you oftentimes will come up with new things. You're solving problems. You're figuring new things out. All of that is times when you want to sort of think about protection strategy. You probably want to have some sort of a kind of formal, you know, process in place where the technical folks on your team at least have access to or know where a disclosure form is, and, you know, your attorneys can provide you with that type of form. So you're at least just kind of keeping track of, you know, what you're developing, and then, you know, going through the strategic decision process as to what tool to use to protect the stuff. You know, working with IP counsel, right, there can be sort of sophisticated filing strategies, making sure that, you know, you're filing provisionals and then sort of following up on those provisionals during that intervening year I talked about with periodic updates, and also making sure that you file patent applications, something called continuing patent applications, which keeps patent families alive and make sure that they remain available to adjust and mold as your product adjusts. Next slide. Okay, and then just, it doesn't really fit in super well, except it does fit in with, like, sort of, you know, if you want to work with sort of IP counsel, but pretty much everything that we've been talking about in this presentation has been around sort of protecting your own assets, right? Making sure that if you have a technology or a product, that you're selecting the right assets to make sure that you have your moat, you know, defended from other people encroaching. I think it's just at least worth mentioning that, you know, any sophisticated IP strategy or sophisticated IP thinking should also consider whether or not there are any third parties that have rights that cover what you are doing, right? And you know, because again, having, you know, your own moat is helpful, being able to prevent other people from coming into your castle. But if your castle is inside of somebody else's moat, such that they can basically come up and have a court say, you got to just, you know, basically deconstruct this entire castle because you're infringing on our IP, well, that's arguably even a bigger problem for the company than if you can't build a moat at all. So freedom to operate, what it really, you know, oftentimes this is referred to in the space as freedom to operate, right? Ensuring that nobody else has rights that is sort of hindering you from operating. You know, again, it's a good thing to do when you're working with IP counsel, and it's a good thing to do sort of periodically as you're sort of developing, you know, new ideas, making sure that those ideas, you know, don't infringe on somebody else's rights. And it's important to note that just because you get a patent on something, right? I mean, maybe I should have another graphic for this, right? Which is, you can prove to the patent office that you've, you know, come up with something that is new and different and non-obvious, right? You can come up with a patentable thing. But that patentable thing, you know, might be encompassed within a very broad patent that somebody else has, right? Like, so for example, if somebody has a patent on, you know, a device comprising elements A and B, right? They have that patent. right? You can actually get your own patent on a device comprising elements A, B, and C, right? Because it meets the criteria that element C is something new and non-obvious over stuff that's been done previously. But it doesn't mean that you're free from the sort of the coverage of the patent that has only elements A and B. So again, having a patent does not mean that you have FTO, and so studying FTO is a prudent thing to do. And that's basically it. You know, you know, if you're infringing somebody else's IP, it's a strict liability tort. That means that lack of knowledge doesn't matter. Like you're strictly liable. So the fact that you didn't know about something doesn't get you off the hook for that. And typically the damages for patent infringement are, there's a couple different ways of calculating it, but most often it's something called a reasonable royalty rate. So you end up having to pay you know, damages at the end of the day to the patent owner, and many times, depending on the size of the patent owner's business, that can be, you know, a threat to your business. So again, not really the focus of this presentation. This presentation is making sure that you can build your own moat, but I do just like to mention that before you can really fully engage in building your own moat, you want to make sure that you've got, you know, freedom to operate. Next slide. Okay.
Oh, and that's it. So if you have any questions, we have some time to take some questions. Some are already coming in, but just a reminder, if you have a question, there should be a question panel on the GoToWebinar control panel. Just enter those there, and I'll ask those questions to Marty. So question that came up, do you have a rough order of magnitude cost to budget for a software patent?
Yeah, so order of magnitude, right? And it, you know, again, if you should work with good counsel that understands where you're at in your business cycle and can sort of stage and structure your costs accordingly. So you know, I'll give you your classic, you know, patent attorney or your classic attorney answer first, then I'll give you a real answer, which it really does depend, right? Because if you file like a provisional patent, right, it can be, you know, a different sort of cost than a non-provisional patent, and it depends on, you know, who's doing the drafting of the patent, if it's your attorney versus like you know, the client actually putting together a robust disclosure. But on average, I think to file a patent application, to get a patent like in condition to be examined by a patent examiner, you should budget $15,000. And then on top of that, every time that the patent office acts on your application, like if they reject it and you need to review it and respond to it, you should budget about $5,000. So and then you should budget to have to go through 2 or 3 of those kind of cycles before you actually get a granted patent. So again, very rough numbers, but order of magnitude, you should be budgeting around $30,000 in order to get a patent.
Cool. Another question that came up is, how should founders think about IP representation versus other legal representation, maybe business counsel or whatever? Should we all have the same firm, or can you pick lawyers from different firms?
Yeah, so this question, we get this question quite a bit, right? Because like people may know, like there are boutique firms, right, that do just sort of like one thing. And then there are sort of like more general practice firms, like I was describing at the beginning, like my firm that has like kind of like an integrated group that does, you know, all of these different services. And there's pros and cons to each. Obviously, you know, I've kind of built a sort of kind of full service firm, and I operate inside of a full service firm. So I think that you get a lot of benefits from your different sort of legal teams speaking with each other and communicating with each other very closely. For example, many of these IP assets that we were talking about today, oftentimes those are the things that are examined when, or diligenced when the company is doing a fundraising or the company is doing M&A. And so if the lawyers that are sort of guiding you through your financing or through your M&A, you know, are sort of, you know, on the same team with the lawyers that put the IP strategy into place, that leads to a lot of synergy that I think is beneficial. As companies get bigger, right? If a company is very large, right? Like a, you know, one of the big strategics or something like that. Well, in that case, you know, I think that there's a pretty good case for sort of segmentation. They maybe don't necessarily need. They've actually have an in-house team of lawyers that are kind of serving that function. But my personal view is that for companies that aren't of a size where they have an in-house legal team, having one integrated outside team that has all of your legal functions is a compelling approach.
Okay. Another question, there's actually 2 or 3 questions around this, so I want to combine them in one, but they are on geographic coverage. Where should one file the patents? Is there especially in MedTech, is this set of geographies, the US, part of Europe, or other places that you should always file? Or is there, what are your thoughts on geographic coverage?
Yeah, so the first thing to note is this is really a patent question, right? Because like, again, with your strategy, if you're keeping something as a trade secret, your strategy is just keeping it secret, right? We're not filing for anything, right? But on the patent side of things, yeah, I usually have a matrix because filing in foreign countries, well, actually, let me take a step back. Let's start here. If you want patent protection in a particular country, patents are territorial in nature. So just if you have a patent in one country, that doesn't mean that you have a patent in every country. So for you to get patent protection in each country, you need to actually separately file in each of those countries and go through a separate examination process in those countries. There's some efficiencies, but by and large, you're doing a separate process in each country. So particularly for MedTech companies and particularly for earlier stage companies, you need to have some, you can't file everywhere in the world because it just becomes prohibitively expensive. So I tend to rank, so at a certain point, you just have to make a choice as to like, well, where does it make sense to file? Where is it economically prudent to file? So I tend to rank kind of countries by a couple of criteria. The first is size of the market, right? Size of the relevant market. And the second is how highly functioning the patent system is. Even if I get sort of a patent there, am I able to actually enforce the patent or do anything with the patent there? And then based on those 2 criteria, there's basically a tiering system that I come up with. So like the first tier clearly for US companies is US, right? But outside of the US, tier 1 is generally Europe. I mean, Europe kind of is above everything else, right? It's a very big market and it's a very high functioning patent system. Then you kind of get into tier 2, which is like good opportunities, but like there's like kind of some defect, right? So Canada, very high functioning patent system, but kind of a smaller market, not super small, but kind of smaller. Japan, high functioning patent system, but kind of a smaller market. China, huge market, but slightly less high functioning patent system. Australia kind of falls into that bucket as well. Very high functioning patent system, but smaller market. And then outside of that, honestly, many of my MedTech companies do not file in, India, big market, but like very low functioning patent system. Brazil, same thing, right? So again, if you could, would you file everywhere? Sure, but like we end up just having to make sort of practical decisions. And the only caveat to that is if you're doing that's generally how I analyze it with my clients, with a couple of caveats. One is wherever you're doing your manufacturing, that's a good place to have patent protection. So if you're doing your manufacturing in China, you should probably have patent protection in China. And the other is, not that this is always the case, but if you happen to have like a natural acquirer that is located somewhere, it might make sense to have patent protection in that country because they might be interested in IP rights there. Not always, right? I mean, many Israeli companies are headquartered in Israel. They have no patents in Israel because Israel is a relatively small market. So that's not always the case, but it's something to consider.
Cool. Another question around the process. So when you file a patent, obviously until you get the patent, so you're disclosing some of the stuff, right? When the provisional, after a year of filing the provisional, it becomes publicly available. Is there any protections that you get? What stops someone from looking at the provisional and says, I can do that? What are the protections once you file, but you don't actually get it?
Yeah, it's a really good question. So the bottom line is, patent applications publish 18 months after their earliest priority date. So 18 months after you file your provisional, if you convert it into a non-provisional at the 12-month date, 6 months later at the 18-month date, it's going to publish, right? That is, by the way, only if you want to have international rights. The US didn't used to make patent applications publish, but all foreign countries did. So we actually kind of gave up that right in an international treaty that I really won't bore you guys on now, but we gave up that right. And you can actually still request that your patent application not publish, but you cannot pursue foreign rights if you do that. So some companies that are only interested in US rights, is actually a good thing to do, is to actually not have your patent application published. But if you ever want to pursue foreign rights, it has to publish at 18 months. Now, to the question, you're right, you're at a bit of risk there, right? Because you can't actually enforce your patent until it's granted. So there's a period of time when you have a published patent application out there and you don't have issued rights to be able to stop somebody from doing something. That is a risk. The way that the system sort of accounts for that is damages that you are awarded on your patent protection go back to the date that your patent application first published, so long as you put the infringers on notice of your patent application. And one way to do that is to send somebody a cease and desist letter, but another way to do it is to mark your products with your patent number. So people may have seen before, right? Like when they buy a product, there's actually like on the labeling or the packaging, this product is protected by US patent, Apple, whatever. If you mark your products, that's considered to be giving notice. And again, if your patent never issues, there's nothing you can do about an infringer. But if it does issue, the damages that you're going to be awarded will go back to the date that your application first published.
Okay. We have time for one more question. When should one do an FTO analysis? During development or before launching a product on the market?
Yeah. So here again, right, like, and it's all about kind of management of resources and time and budget and all of these things, right? So there's different like levels of FTO analysis as well, but ultimately, right, in a perfect world, if everyone was flush with cash and could spend, whatever, you would actually do it at both stages, like pre-development to make sure you don't develop something, that's going to infringe third-party IP, and pre-commercial, pre-launch. As a practical matter, it's more important to do it pre-launch because you're not, just developing something, you're not really at that much of a risk. You don't want to sort of waste that time and energy kind of going down a hole that ultimately you end up finding you have an issue. But if you don't have sales, then, it's pretty hard to make a compelling damages case against you. So generally speaking, and just from a cost perspective, people should know, right? And again, there's multiple ways to manage this as well, depending on who's doing the analysis, who's doing the searching. But FTOs can get expensive. They can also range in the $30,000 to $50,000 range for sort of a formal FTO. As a practical matter, you want to definitely do one before commercialization, and then as resources allow, maybe earlier as well.
Awesome. We ran out of time. There's some couple of questions. We'll try to get answers to those questions. If you want to
if anybody has questions that I didn't answer or other things that occur to them, obviously my contact information is right here on the slide. So feel free to shoot me an email or give me a call, and I'm always happy to chat with folks offline as well.
Awesome. Thanks, Marty, for your time. Thanks, everyone, for joining. I personally learned a lot from today's webinar. And thanks, everyone who joined, and all of you have a great day ahead. Thank you.
Thanks, boss. Thanks, everyone. Bye-bye.